to the regular practices of the court. That's all.
All right. And just so you're aware, Attorney Moss, I don't believe they're accepting people on pretrial services just because of the pandemic. They haven't been able to close out cases, and they've been over capacity for some time. I know they're trying to reduce their roles, but I don't think we're at that point yet. They typically alert me with an email and say we're able to take people on pretrial services again.
That's understood, and Mr. Van Wagner and I had conversations to that effect, and that's why the state's not affirmatively recommending it.
All right, thank you. And Attorney Van Wagner, what's your position on bail?
Your Honor, may it please the court and counsel, let me start with the cash bail. I respectfully believe that the bond should be a signature bond in this case, and I'll state my reasons quite simply. My client, as identified in the report the court reviewed, has no prior record. He is a resident. He is not only a resident of the state of Wisconsin, he owns 2 residences here. He has substantial ties to the community. He is in a marriage, and he has children, and he is committed to them. And regardless of the, if you will, the seriousness of the charges or even the potential penalty, the presumption of innocence is still part of this proceeding. But more importantly, the simple question would be, why is he any different than anybody else who was for the first time accused of a child pornography offense in this county? Those are cases that ordinarily result in a signature bond, absent evidence of attempts to flee. There are none of those here. So as a practical matter, I'm prepared to address some more, but I don't think that, let's put it this way. He's a professional. He does own a home. He has no particular place to go but here. The state hasn't suggested any indication that he would go anywhere. And so the imposition of $2,500 cash bond is hardly the kind of anger that would keep somebody here who is as smart and as experienced and as professional as he is. On the other hand, there's nothing about a signature bond that is going to cause him to suddenly up and leave his family, leave his extended family, and leave the support group he has among his friends. He has a wide group of support, and that won't change after today. So I don't believe it's necessary. And I've had a couple child pornography cases for initial appearance in the last month, and those have received signature bonds as well. So the fact that he were to get one would suggest that somehow he'd be treated differently by this court, perhaps. I'm not suggesting the state is doing that. The state is perfectly within its rights to ask for it, and their reasons were articulated properly under the statute. I do want to address the conditions, and I want to start with the children one. He does have 2 children. The court has read the complaint and the Riverside affidavit. There is not a word in there that suggests that my client directly did anything that tried to put him in touch with any minors, his or anyone else's. Otherwise known as a contact offense, there's not a scintilla of factual suggestion in the criminal complaint that other than the use of the internet, that he ever posed a danger to any children. Politicians can pass laws for reasons they want and to get elected. But this court has to look at the facts in the complaint and decide the following question. Why should he have to have supervised contact with his own children at this point? CPS has been notified. They'll look into it. They'll place things, they'll put things in place if they think they're necessary. And my client and his husband and the state are all aware of CPS's involvement. So I think this court should defer to CPS for whatever they think is necessary in the way of protective services. We must remember that my client has a constitutionally protected interest in his own children. And while that doesn't strip this court of the ability to place such an order, in this particular case, it's not reasonably related to any articulated fact in the complaint or in the state's argument. If they come up with one in response, I'd certainly ask the chance to respond. I think the restriction should be no unsupervised contact with minors except for his own 2 children. That's the first point. The second point relates to the use of the internet. And I'm going to circle back, to use a commonly popular phrase, to a hearing I had a week ago in a child pornography bail hearing, first offender, similar circumstances to this one, state investigation, search warrant, seizures. And in that case, Commissioner Hansen, who I know this court knows well, was asked to place various sorts of internet restrictions on the defendant. And he said that if the internet were to somehow be restricted, the list would grow longer than a sheet of paper, and it'd be impossible to manage, and the notice wouldn't be good. The state has proposed that my client essentially have no way to reach the world except through a landline. There's no suggestion he even has one. If he does, that's not exactly what the parent of children might need if they were out with their children. Let's say he's with his children and he's transporting them somewhere and an emergency arises. In this day and age, we have the convenience and the facility of a cell phone to get them help. This is the problem with a restriction like that. It takes what has become, in a short 20 years, an essential element of parenting and of life, and requires him to find ways to communicate beyond that. I don't think it's necessary in this case. I think the court could certainly, if it wanted to try to indulge the state, come up with restrictions that somehow related to his use of social media sites, but even that seems to have been a failure in administration later. He's never sat in jail before. He's never been charged with a crime before. And that alone ought to be enough, you would hope, incentive that he wouldn't use the internet for any illicit or suspected illegal purposes. So the idea of not having a phone at all, I think, should be considered a non-starter because there's no suggestion that using that phone at this point is going to endanger the community. Secondly, the state has asked for a complete ban on use of the internet unless he is supervised. I talked about this with counsel for the state. I communicate with all my clients by email. I ask them to not only receive email, but keep tabs on their case for tracking purposes. People bank online. Commissioner Hansen pointed out that his doorbell is connected to the internet. It would be almost impossible not to access the internet in this day and age in any way, shape, or form. In fact, our car communicates with the internet. So as a practical matter, the administration of that understandable request is impossible. It doesn't give proper notice. I would suggest that the court simply indicate that he may use the internet for whatever purposes the court wants to list, or that he not use it at all. And I don't know how you live in this day and age, particularly as a parent of middle schoolers who have to use virtual school. And I posit this one thing. If he is assisting his children with school, he can only do that with another person there. I think the state agrees that if he were to be communicating with me by internet, either in a Zoom meeting or in a phone call that uses internet protocol, or for that matter by email, that he wouldn't have to be supervised there. Well, that's a relief to me because that would violate the attorney-client privilege and we couldn't communicate. I'd have to meet him and only meet him. The state basically wanted him to have somebody standing over his shoulder anytime he used the internet, only on a computer, and that's it. And I don't know that even that is going to serve what the state's purposes are. So I suggest this is an unmanageable, if understandable, request. I would oppose it. I think I covered the two restrictions, and I'll stop there. Thank you.
All right. Any rebuttal?
No, Your Honor.
All right. Well, obviously, this case has generated some media, and I think I should probably explain the process for people who are not attorneys and what this is all about. This is an initial appearance. We set conditions of bond. It is not a trial. When we're addressing conditions of bond, if there is to be cash bail, under the Wisconsin Constitution and the statutes, cash bail should only be imposed if it's necessary to assure appearance in court. It gets a little bit murkier when people are out on bond, but there's, I think, no dispute that you can't impose cash bail for other purposes such as protecting the public or things of that nature. It's only to assure appearance in court. And the statute under Chapter 969 sets forth a number of factors that one looks at in order to determine is there a reason to believe that somebody is a risk not to appear. People often say flight risk, but that's not the language in the statute. It's a risk not to appear. I think if there's a risk not to appear here, though, it's probably a flight risk as opposed to somebody who's just going to negligently forget his court dates and not show up. So what are the factors that we look at? We look at their ties to the community, things like employment and housing and things of that nature, family and friends and other reasons that they might not want to take off and leave the area to flee the charges. We look at, are they somebody who's out on bond? Have they ever missed court dates before? We look at prior criminal record. We look at whether the charges have mandatory minimums and the potential penalties and the gravity of the charges and the seriousness of those charges. We also have the benefit in Dane County, at least, of having an evidence-based tool, a public safety assessment that tries to gauge risk as far as people failing to appear in court. And it's been tested to see that it's something that is pretty good at predictive behavior as far as whether somebody's going to show up in court. That evidence-based tool here suggests that you say Blomme? Mr. Blomme is a signature bond. He's very low risk. In fact, he scores a 1 out of 6 on the failure to appear scale, a 1 out of 6 on the new criminal activity scale. That's not surprising if he doesn't have prior criminal history. That's typically how somebody scores out. Obviously, people who've missed court dates before have higher scores. I think many of the factors as far as whether I should expect that Mr. Blomme is going to appear in court weigh in his favor. He at least had employment recently, has housing, has some ties to Dane County, has a husband or a significant other and children, and reasons why he wouldn't want to leave the jurisdiction. On the other side of the coin is the stuff that the state correctly points out. These are very serious charges. The allegations are certainly disturbing. There are significant potential penalties if convicted, and there are multiple counts, and there are mandatory minimums of 3 years on each of those counts. And certainly if I were to just look at the 7 charges, I think it was, and multiply that by 3, there's a significant potential sentence. But I think I wouldn't be doing my job, because I've been doing the court commissioner stuff for probably 8 years, been a prosecutor before that, and I kind of have an idea as to how cases ultimately get resolved and how those are disposed of. And I think that is a relevant fact to look at, because that really plays into how much incentive is there to not show up in court. Most of the cases for possession of child pornography where there isn't a contact offense, as Attorney Wagner refers to it, result in the mandatory minimum, but not run consecutively and nothing beyond the 3 years. There have been exceptions. I think they're relatively few and far between, and those sentences are still pretty close to 3 years. I think they've been in the 4 and 5 year range. Not typically decades in prison, which I think certainly provides extreme incentive for somebody not to show up in court when they're likely to get decades in prison if convicted of the charges. I also see what are typical bail situations for people with no prior record who are charged with multiple offenses of child pornography. In general, I think those are signature bond cases, and the track record is that if they've got strong ties, they tend to show up. And I think that's important in the analysis of whether Mr. Blomme should be expected to show up or whether he's going to take off. If I'm setting cash bail, is $2,500 an amount that's going to do the job? I would suggest that it's probably not. He's been able to hire private counsel. If he has decided, I'm just going to take off, I'm not going to stick around and see how things play out, and the potential of at least 3 years in prison, maybe more, is enough to do that, I'm not sure that $2,500 is enough to do the trick. I think given his ties, the evidence-based tool, it's hard for me to come to the conclusion that Mr. Blomme is much different than many of the other people we see with no prior record charged with similar charges. And I don't think I should treat him any more harshly or less severely than those other people. And it's just hard for me to come to a conclusion that he's going to essentially give up his life, his relationship with his husband, children, and take off and essentially be on the run for the rest of his life, is what I would have to believe. I don't think the evidence bears that out at this particular point in time, given what's been charged here. So I think a signature bond is appropriate. I think that will be sufficient to assure Mr. Blomme's appearance. And I think it's consistent with other people who are similarly situated with similar number of charges for child pornography with no prior record, significant ties, no allegations of sexual abuse to minor children. So I will order a signature bond. In regards to the conditions, I get where the state's coming from in regards to the no internet. I kind of agree with Commissioner Hansen on that. It's nearly impossible for a lot of people to run their lives because it's become so ubiquitous to use the internet for things. As Commissioner Hansen apparently has said, his doorbell's hooked up to the internet, and he's technically violating the law if he's monitoring that or changing his thermostat. I think we can accomplish the state's legitimate concerns and certainly the court's concerns in regards to Mr. Blomme using the internet to download and view child pornography. One, he's got a condition of bond that he not commit any new crimes arising to the level of probable cause. So if he were to do that, that obviously is a violation of his bond, and he can be charged with felony bail jumping charges. I haven't heard any real reason why he needs to use, I think it was Kik that was referenced to, and other social media applications, I guess, for lack of a better term. I'm not super savvy with all of that. But I don't think he needs to be on social media websites, nor do I think he needs to be using any file sharing devices, which are often used by people who are viewing and downloading child pornography. If that is problematic in regards to anything that he might legitimately have to do, you can speak up, Attorney Van Wagner. I guess I'm not thinking of any real legitimate reason why he needs to use social media applications or any file sharing applications.
Understood.
All right. I certainly think it is appropriate.
I'm sorry, Commissioner. I didn't hear Mr. Van Wagner's response. He faded out.
Understood.
Understood,
thank you.
Lori.
Thank you.
All right. I certainly think it is appropriate that he have no unsupervised contact with any minors. The kids is, a more difficult situation. He does have a husband who I have to assume is going to take whatever necessary precautions there are to ensure that his children aren't victims. There is no indication or evidence in this complaint or on the record to believe that he has assaulted his children or other people. And it has not been disputed that CPS is involved in investigating the situation. I expect that the husband will probably monitor the children and not put them in a situation where they could potentially become victims. I would have expected that they may have appeared today if they thought or had any concerns in regards to the children and thought that a no contact prohibition was appropriate, or the need to have an order that says there may be no unsupervised contact with his own children. Now that may be practically what happens and how his significant other treats things. I'm not sure that it's necessary for a court order at this particular time. I believe time limits were already waived. Attorney Moss or Attorney Van Wagner, have I overlooked anything?
Nothing from the state.
Just to be clear, Judge, I want to make sure that my client hears the court, make sure that what I understand of the conditions are what he understands. So the court is not imposing any sort of restrictions about the internet, except he shall not use file sharing programs and he shall not use in any way any social media sites. That's number one. And number two is that he is not permitted to have, did you say no unsupervised contact with minors, except that does not include his children? Is that how you said it? Or did you say no contact with minors except his
And
own
maybe
children?
I wasn't as clear on the language. In regards to the internet, I'm simply ordering that he not use any social media sites like Kick or anything else that's construed as a social media site, Facebook, those sorts of things, nor to use any file sharing programs. In regards to the prohibitions on the children, I'm ordering that he have no unsupervised contact with any minors except his biological or own children.
When you say biological, if they're adopted, you're including them.
Well, that's why I then said own children, adopted or biological.
That clarifies things.
Caught myself and realized that they may not be biological. I didn't know that, and that was just an assumption on my part, and probably incorrect or inappropriate to assume things, obviously.
Thank you for the clarification. Thank you.
No, it was a valid question. All right, if there's nothing else, then we'll be adjourned for today.
We will not be setting a prelim date then?
The clerk will get a date, I think.
I do have that date available. We have right now April 29th at 3:20 in branch 16.
Does that work for council?
Ray, what time did you say?
3:20.
Yeah, that works. And that, but presumably is by Zoom, Commissioner and Ray?
It will be. That Zoom information will be on the notice. You're opted in, so you should receive that electronically.
Thank you. Understood. Nothing further.
All right, and Attorney Moss, did you indicate if that works for you and your witnesses?
That does work for me. Thank you.
Okay, then we'll be adjourned. Thank you.